Okay. This is actually very unique. We are live, so this is Senate Health and Welfare, we're back. And we're continuing our work on S-192, we're going to go through the draft. Complete. We're complete going through the draft, and then there was some testimony that we received on February 12th. That I think the Commissioner of or Mental Health, Department of Mental Health, may want to comment on. So I'll hold that thought. But Katie, why don't we go to what page?
Page 25. Yes. So Katie McGlynn, Office of Legislative.
So let's go finish going through, and then we'll go back and go to that proposal, and then we'll go through the bill yet again.
Okay,
Okay.
great. So. Okay, we left off at section 8846, just to sort of remind you where we are in the bill. We are in the second half of the bill that pertains to individuals with intellectual disability. This section 8846 has to do with continued custody care and rehabilitation. So that's where we left off. Okay. Subdivision A1. If prior to the expiration of any previous commitment order issued under Title 13 or this subchapter, the commissioner believes that a person is a person in need of continued custody care and rehabilitation, the commissioner shall initiate a judicial review in the family division of the Superior Court. The commissioner shall, by filing a written petition, commence proceedings for the continued custody care and rehabilitation of a person. The petition shall include the name and address of the person alleged to need continued custody care and rehabilitation. When we met maybe last week, you decided to keep and address. And also a statement of the current and relevant facts upon which the person's alleged need for continued custody care and rehabilitation is predicated. In subdivision 2, notwithstanding the previous subdivision, a person may initiate a judicial review under this subchapter at any time after 90 days following a current or continued commitment. A current order of continued commitment. In subdivision 3, any commitment order for custody care and rehabilitation or continued custody care and rehabilitation issued in accordance with Title 13 or the subchapter is to remain in force pending the court's decision on the petition. And this is the piece that Stuart keeps emphasizing, that that the petition, if the commissioner is filing a petition for continued treatment, that the person's underlying order for commitment stays in place while the court makes a decision on continued treatment.
Right, so there's not a gap.
Exactly.
Right.
In subdivision 4, if the commissioner seeks placement of the person alleged to need custody care and rehabilitation at a forensic facility, the petition for continued custody care and rehabilitation shall. So we've just talked about commitment generally, now placement at a forensic facility. The commissioner has to expressly state the reason for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, and include a recommendation of the Human Services Safety Panel. So this is the same conversation recent. You had said original or renewed was language you were looking at in the mental illness context yesterday. So I imagine whatever decision you make for one, you'll probably make in both places.
Okay, so we need to go back and make that decision. But so the question is for a reconsideration of commitment. Do we need to have, should we have a new recommendation from the PAM? That's a question both for mental health and for intellectual disabilities.
So I believe that yesterday we made the decision in the intellectual disability section
In the mental health section.
well, no, in the intellectual disability section, that's where we're at right now. To extend the initial.
Oh, the initial
to
commitment to a year,
To a year.
right, we did that.
So. And then the mental health one is still at 90 days.
Oh, good point.
Correct?
Yes.
Okay, so, but in both cases, I think that if we're gonna have this panel, which I'm not actually sure we need, but if we are gonna have it, we should have them do a renewed one. Because, first of all, a year is a long time. And a lot can happen in a year. And the reason we extended it to 2 years, because the argument was made, well, 90 days is too short. People with intellectual disabilities are not gonna, there's not gonna be a rehabilitation or
Right.
much change in 90 days, but a year, there could be a lot of change. And I think we need a renewed look from that panel. And then for mental health, 90 days actually could be a significant amount of time if somebody's on medication and they've, had some progress. So in both cases, I do think we should have, if we're gonna have this panel, should be renewed.
Okay, so you're suggesting a new one, but in particular, I agree with your comment about having a new one here for the
Yeah.
intellectual disability. And then, I'd like to hear from DMH if there's any comment. So when we go back through the bill, we'll go back to the mental health issue again, but for now, let's say we want a new, unless I hear differently. Cause
No, but I do have a question. Is it up for discussion whether or not we have the panel? Cause that keeps floating around, but no,
we can talk about it, but I think at this point, it's been in here for a long time. And then to take it out might be a pretty big decision, since so many of the recommendations for commitment or reconsideration are linked in with the panel and the commissioner. There's a lot of concern that having one person make the decision might not be appropriate here. So that
Makes sense.
yeah.
I mean, I thought the panel was a fine idea until yesterday when Karen was explaining, and I'm sure Karen's floating up there
She
on the
is.
screen.
She's
Hi,
there.
Karen. And that ultimately the commissioner makes the decision anyway, and the
Mhm.
commissioner can ignore the panel's recommendation anyway.
Right.
So it just seems like the panel is a little bit superfluous if nobody's gonna listen to them.
Let's ask that question. We'll go back, let's go through the bill. We'll ask that question of Karen, but the other folks who are in the room with us, and I think probably on Zoom, who might comment on that would be some of that, for example, legal aid. Might want to make a comment on that. And did we get legal aid? They're up on the screen, so we'll have legal aid
Right.
on that.
And whether they should be on the panel if we're gonna keep the
Yeah,
panel. whether we
exactly.
should include
So
legal aid.
That's probably a good question. All right, so in this case, where we are right now on page 27,
This is
a new,
Who gave me this? This is really good. Thank you, Madam Chair. You go.
okay, so, how would we word that, Katie? Include
A renewed recommendation.
a new. Let's put that in, we may hear it differently as we go up to the Zoom world. Go ahead.
In subsection B, upon receipt of the petition, the court is to set a date for the hearing. I asked if you want to have a time frame on that or just to be silent.
10 days. Is that typical?
What is it for mental health?
I don't know off the top of my head.
Well, I think it is 10 days.
That seems,
Yeah, I
I
think it is.
think what it was, so that's why I suggested, I wrote down 10 days.
Okay. I'll mark 10 days.
Let's put 10 days in there. We're also will. And remember, this bill also has to go to the other body.
One, judiciary, too.
No, they just don't look at it.
Oh, really?
They're not gonna, well, this is it. What we do is what is gonna happen, pretty much. Unless we do something egregious for courts.
Do something egregious to the courts.
Okay,
Subdivision C1, if at the completion of the hearing and consideration of the record, the court finds by clear and convincing evidence at the time of the hearing that the person is still in need of custody care and rehabilitation, commitment shall continue in a designated program in the least restrictive environment consistent with the person's need for continued custody, care, and rehabilitation for up to 1 year. If the court finds at the time of the hearing that the person is no longer in need of continued custody, care, and rehabilitation, it shall discharge the person from custody of the commissioner in accordance with the next section. In determining whether a person is a person in need of custody, care, and rehabilitation, the court shall consider the degree to which the person has previously engaged in or complied with the treatment and programming provided by the commissioner. Okay, in Division 2, in a petition in which placement at a forensic facility sought, a court shall first determine whether an order for continued custody, care, and rehabilitation is appropriate. If the court grants the petition for continued custody, care, and rehabilitation, it shall then determine whether the placement at the forensic facility is appropriate and the least restrictive setting adequate to meet the person's needs. If so determines, the court shall order the person placed in a forensic facility for a term not to exceed the duration of the continued custody order for continued custody, care, and rehabilitation. And then we move to discharge from both commitment or placement or both. In subsection A, if a person is committed under Title 13 or the subchapter, they may be discharged from an order of custody, care, and rehabilitation, an order of continued custody, care, and rehabilitation for placement at a forensic facility in either of two ways. The family division of the Superior Court, after judicial review pursuant to subsection B of this section, or an administrative order of the commissioner pursuant to subsection C. So first in B, a person under a commitment order for custody, care, and rehabilitation, or a commitment order for continued custody, care, and rehabilitation under this subchapter shall be entitled to a judicial review of the person's need for continued custody, care, and rehabilitation pursuant to the preceding section. If the court finds that a person is not a person in need of custody, care, and rehabilitation or continued custody, care, and rehabilitation, the person shall be discharged from the custody of the commissioner. The judicial order of discharge may be conditional or absolute and may have immediate or delayed effect. And then into A, we get to the forensic facility. So in reviewing the placement of a person receiving treatment and programming at a forensic facility, the court may determine that while the placement at a forensic facility is no longer appropriate, or that the setting is no longer the least restrictive setting adequate to meet the person's needs, the person is still a person in need of continued custody, care, and rehabilitation. In this instance, the court shall discharge the person from placement at the facility while maintaining a person's commitment order, continued commitment order.
Right. Commitment to another facility.
So they would continue to be committed in the custody of the commissioner of Dale, but they would presumably receive treatment and programming elsewhere. Thank you. Okay, and then we need to get some of these notification pieces. So in subdivision B, when a person subject to judicial review pursuant to this subsection is receiving treatment or programming at a forensic facility, the prosecutor or victim or both may file a petition with the court as an interested person concerning whether the person's discharge from placement at the forensic facility is appropriate. So I just want to sort of stop and say, remind us what this does and doesn't say. So this does not allow the prosecutor to comment on, or the victim to comment on commitment generally. This is limited to placement in a forensic facility.
Okay.
And then in subsection C, we're switching. So we so far have been talking about discharge through the courts. The court is looking at a petition and saying the person doesn't meet criteria.
Can I ask a question, Madam Chair?
Go ahead.
So I was just processing what you just said before. So this is but this is whether the person's discharged from placement. So the prosecutor and the victim could comment on whether the discharge should be.
Yes.
Okay, not the placement into, but the discharge from.
Yes, in this case, and I'm wondering what the role would be in the placement.
That is, I think that might be one of the questions that we want to look at.
Okay. Let me look at it, I don't.
It may relate to the testimony that was sent in.
It means,
I thought that was just specific to mental health, the mental health part of it. This is the disability.
Yes, but there's some having a
Having a parallel.
the parallel.
Um,
Hold that thought. Yeah,
Every once in a while, I wish this had been two bills.
Huh?
Every once in a while, I wish this had been two bills, just because it's hard to keep both track together at the same
The
time.
new stuff that Katie drafted is easier to follow.
Yeah,
yeah,
Stuff.
it is.
drafting
Good
is
job. Good job.
This is not a reflection, it's just.
It's complicated.
Yeah.
It is very complicated and takes time to really get into it. It does.
so, subsection B, we were talking about a court ordering a discharge. Now, in subsection C, we're focused on the commissioner, observing that a person is not meeting the criteria, issuing a discharge. So if the commissioner determines that a person is no longer a person in need of custody care and rehabilitation or continued custody care and rehabilitation, the commissioner shall issue an administrative order for discharge of commitment. An administrative order for discharge of commitment may be conditional or absolute and may have immediate or delayed effect. At least 10 days prior to the effective date of any administrative order for discharge by the commissioner from commitment, the commissioner is to give notice of the pending discharge to the committing court and to the prosecutor. And then B, in reviewing the placement of a person receiving treatment and programming at a forensic facility, the commissioner may determine that while the placement at a forensic facility is no longer appropriate, that the setting is no longer least restrictive to meet the person's needs, the person is still a person in need of commitment. In that instance, the commissioner is to discharge the person for placement at the facility, but maintain the person's commitment. So same language as in the previous subsection.
So that means they could go somewhere else. Yeah.
In subdivision 2, when a person is subject to administrative discharge, is subject to an administrative discharge and they're receiving treatment and programming at a forensic facility. The prosecutor is to provide notice of the pending administrative discharge from placement at a forensic facility and from commitment, if applicable, to any victim of the offense for which the person has been charged, who has not opted out of receiving that notice. Top of page 31. Entitled to appear and call witnesses in the underlying criminal case. The state's attorney, or office of the attorney general or the victim, or both, may request a hearing on the person's pending administrative discharge from the person's placement at a forensic facility, which shall be heard within 10 days after the request.
Is that word within a problematic, not, you look at it and you think, okay, what's the problem with that? Does that mean the 10th day is included?
Yes,
Okay. That's all I wanted.
I forget, there was a typo there, which is why it's highlighted.
That's why you did it.
I
Okay.
forget what,
Why was that highlighted?
I forget what the word had been previously, but
Okay.
once the hearing is requested, the pending administrative discharge shall be stayed until reviewed by the court.
So even though the request is made within 10 days, the court could take a lot longer.
Mhm.
Is that?
Probably not much be done about it. They're working.
Can we tell the court that they have to do it sooner?
Yes, it's the policy decision, I don't know, you probably want to hear from the courts as to what is feasible. You have,
we could hear from Judge Zone on that. We can, why don't we do this? Can you reach out to the Judge Zone and ask him about the consequences of putting in a limitation here, timeline? If any, and then we'll make a decision about maybe testimony on top.
You, if you would like to take it, have, a hand raised. Of the witnesses.
Pretty feasible.
Whose hand is raised?
Sure.
Oh, Stuart's hand is raised. Apparently, you can't see it out there.
Oh, you can?
That's not my screen, yeah.
Did you hear that? That Stuart has his hand raised, even though we can't see it.
Pardon me?
Stuart's hand is raised. Okay,
Oh.
Katie can see it on her screen. We just
Thank
can't see
you.
it here.
Stuart?
Hi,
Right.
hi, Senator. If I may, for the record, Stuart Sher, General Counsel at Dale. I just noticed something as I was reading through this subsection here. This subsection relates to the commissioner's administrative discharge from the forensic facility,
Right.
not the court's discharge. So I'm not sure that it's appropriate to have language in here that says that if the commissioner is deciding to issue an administrative discharge, that the court would stay this, or the administrative discharge would be stayed until reviewed by the court. I think there was an intent to have notice to the victims and to the state's attorneys, but I don't know if there's a process by which there would be a hearing on the commissioner's decision to discharge. But that's a policy decision. I just noted that didn't seem to make much sense.
Can you repeat what you have just said, please?
Sure. So you'll recall that there are two ways for someone to be discharged from either custody of the commissioner or from the placement at a forensic facility. One is by the court and one would be by the commissioner making that decision. This subsection here talks about the commissioner's decision to administratively discharge or to administratively remove someone from the forensic facility, having determined that that's no longer the least restrictive environment. This would suggest that the state's attorney or the attorney general or the victim can request a hearing on the pending administrative discharge by the commissioner. And those have traditionally been considered separate authorities. There's a judicial authority, and then the commissioner has her own authority to discharge. So there wouldn't be a judicial hearing on the commissioner's decision to discharge, either from custody or from the facility.
Okay, so where is the language that we need to change on this? So it looks like the whole section is related to the state's attorney, attorney general,
It's the last sentence.
amendment, or is it,
Last 5 and 6,
or
right?
is it the last sentence? Let me finish.
I think it's all of subsection B. Certainly 2A, providing notice makes sense.
Okay,
So that the parties are aware that the commissioner is planning to administratively discharge from the forensic facility. But I would think that B doesn't make sense for the court to hold a hearing and to stay the administrative discharge pending review by the court. But that's a policy determination, I suppose, but that's historically, those have been separate powers that the judiciary and the executive.
Yeah, so I think, Katie, correct me if I'm wrong, did this language come out of the H-89 work by House Judiciary?
This was House Judiciary.
Yeah, so I think for our purposes, let's take it out, and then when it moves over to the other body, to the House, they can evaluate further.
Okay. Okay.
Yeah, that helps to keep separation of powers issues clear.
Thank you.
No, thank you.
Okay.
Pull the document back up. Screen, okay. Subsection D, whenever a person is subject to a judicial or administrative discharge from commitment, the criminal division of the Superior Court shall retain jurisdiction over the person's underlying charge and any orders holding the person without bail or concerning bail, and conditions of release shall remain in place. Those orders shall be placed on hold while the person is in the custody, care, and habilitation of the commissioner. When the person is discharged from the commissioner's custody, care, and habilitation to a correctional facility, the custody of the commissioner shall cease when the person enters the correctional facility. Then we have language about right to counsel, so it's been renumbered. And then a person subject to commitment or continued commitment under the subchapter shall have a right to counsel, so we're adding continued commitment.
That's one of the things. Yeah, just want to make sure you noted.
Oh, okay. Section 14, so we're sort of, we have a new topic, the competency exam. So we're sort of
Oh,
jumping
this
back
is the
to Title
competency
13.
section, yeah.
Yeah, so this was the language about the psychologist being able to do the exam and removing the sunset. So that's what you're doing here. Section 15 is a fiscal estimate. So by November 1st of this year, this directs AHS to submit a report to various committees of the General Assembly that provides a fiscal estimate for the implementation of a competency restoration program. So new topic. We're talking about forensic facility. This is about competency restoration. Operated under contract with the Department of Mental Health. The estimate shall include varying options dependent upon which underlying charges are eligible for court-ordered competency restoration. Because we know the population that would be eligible for competency restoration would impact the cost and the analysis. And then also costs associated with establishing a residential program where court-ordered competency restoration programming may be performed on an individual who is neither in the custody of the Commissioner of Mental Health or Dale. So that sort of gets at our Venn diagrams, that we know sometimes people who would be possibly eligible for competency restoration might not also meet the clinical criteria for commitment to the Commissioner of Dale or mental health. So in that gap of, they're not under custody and they are not competent to stand trial, where are they located? So this is sort of saying when you're figuring out the costs, assume that there is some type of residential space where competency restoration for this population is happening.
Yeah, that gets interesting.
Can I ask a question?
Yeah.
So by calling this out, what about the costs of competency restoration for people who are in the custody, care, and habilitation?
This is asking for the whole package. So this is asking for a competency restoration program. It would be the current proposal that you had heard is that it would be operated or by DMH or a DMH with contract for a competency restoration program. This language assumes that if a person is under the custody of either Dale or DMH, that the person is somewhere where they could be receiving competency restoration.
Mhm.
But if a person is not under custody, there's a residential facility that would be the place where they are receiving that.
Mhm.
The one sort of interesting piece is, as we know, we have an order of non-hospitalization. So in theory, in the mental health context, somebody could be living at home under the commissioner's custody. And that will be policy conversations in this committee and other committees as to whether such a person, would where they would be receiving competency restoration.
Yeah, that'll be a big discussion.
Another question, the way this is worded, does it assume that competency restoration is possible and appropriate for people with intellectual disabilities? So I think we got some testimony that competency restoration for people with intellectual disabilities is difficult and maybe not as possible as people with mental health. Because it mentions both commissioners, it's sort of making the assumption that
May not be possible. Let's ask that question of Stuart. So the question about competency restoration and those with intellectual disabilities. You have commented previously, but be helpful.
well, I think it was other people, not
Yeah.
Stewart, but
And then Senator Williams has a question.
you're
So can
muted.
we go to judiciary?
No.
No?
Okay.
So specifically as to the likelihood of competency restoration, is that what the question is?
For folks with intellectual
For-
disabilities,
Sure.
is there an opportunity for competency restoration?
I think that's a mixed bag. I think there have been some studies that have indicated that individuals with disabilities can have their competency restored. It's called the Slater method. So there is some research indicating that. I would say that it's probably not as successful as for other populations, but there are some who would say that it can be restored.
So maybe, thank you, Stuart. Maybe what we want to say in here is that they're reporting back a recommendation as to whether to include that population in a competency restoration program or not.
Whether and how. I agree with you.
Yeah.
Yeah, let's do that. Because this is purely draft language based on a 796-page report that we received. So, it's impossible for us to put a program in, but the comment is well taken. So let's put that in, how, whether and how.
Okay.
Yeah.
Thank you.
Is there anything else there that we can think about?
Okay. The next section is rulemaking. So, on or before August 1st of this year, it requires the commissioners of mental health and Dale respectively to file initial proposed rules with the Secretary of State. To the therapeutic community residence rule. I'm pausing because I'm thinking about the word respectively and how there's probably only going to be one rule, one amendment that's filed.
Let's just put down, take that.
Yeah, that's what I'm thinking. And just to sort of ground you in where that is in the process, because the timeline is tight. Is that by August 1, it's sort of the initial filing. We know that it takes, 8 months to a year for rules to go through LRAC. So this is sort of giving a time frame by which the process has to be officially started.
August 1st, 2024, to the Secretary of State. Does that mean it's already gone through ICAR?
No. I think
Okay, just
this is the initial
preliminary.
filing. Yeah.
Okay.
Okay, so this is what is to be amended. First, adding a forensic facility section to the rule, the TCR rule, therapeutic community residence rule. That includes allowing the use of emergency and voluntary procedures like seclusion, restraint, could be chemical restraint, and also the administration of involuntary medication at the forensic facility, which this bill otherwise anticipates. And then amending the existing secure residential recovery facility section of the rule to allow the administration of involuntary medication at the secure residential recovery facility. Last time I walked through this, Karen flagged for me that they also would need, to be able to use emergency voluntary procedures at the secure residential recovery facility, sometimes to administer involuntary medication. So she said that that corresponding change would also be requested.
So that covers, it's covered.
No, I'd have to add the language
I think we should.
to subdivision 2.
Okay.
So it pretty much mirror the phrase in one. In one, we're adding a new section, one we're amending an existing section.
Okay. Okay, so, we've been through it, we've made some changes. We've made some decisions, which is great. Still have a little bit.
Yeah, I don't want you to forget effective dates, because I think that is still in play, so.
I forgot that.
I know. Don't worry, I'm here to remind you. So effective dates, we have this section, meaning section 17, and then the rulemaking section takes effect on passage, that's to, authorize rulemaking right away. And then we have all remaining sections take effect on January 1, 2025. If you remember, I said that I was asked to push back the date when I came back with the new draft, but I made up that date, January 1, 2025. I don't know what date you want there. So that.
I don't know what they should put there. I'm wondering if, the administration can help us with that and whether or not our little trip on Friday will help us with that. So Stuart or Karen, that's the effective date of January 1, 2025 for all sections with the exception of, 16. Hello, Karen. Oh,
Good morning. For the record, Karen Barber, General Counsel of DMH. I would have concern that
Karen.
oh, wait, Karen, we got an echo going on. Does somebody have something on? Try it again. Say,
Can you hear me now?
no, it's pretty bad.
Katie, it looks like you're not muted, your computer. I wonder if that would help.
No, I don't have audio.
Oh.
It's on your end, I think, Karen.
Stuart, is
looked
your
okay.
audio on? Wonder if that wouldn't do it.
Nope, mine was off.
Is anybody else around you with their audio on? Karen?
No. Do you want me? I can try calling back in.
Yeah, try that, please. Wow.
In the meantime, I realized, section 15 has to take effect on passage too, that's the report.
Oh,
It's okay. You can say yeah.
so we need to go back and look at the timing. Whether it's 90 days or a year for mental health on the discharge, the timing for a reevaluation. Is that the one that you were going to? Yes, so.
Is this better?
Yes, thank you. Good work.
Great. So for the record, Karen Barber, General Counsel of DMH. I would ask for more time. I think one of the ideas was that Katie had concern about it kind of being an indefinite period. But my concern with January 1 is we won't know if the legislature has budgeted money next session to pay for this. Like, I think what we need is to assure that there's money in the budget to do the renovations needed either to VPCH or wherever this is going to occur, and there's money to run the program itself. And so without that, we don't want the language to go, we don't want some of the language to go into effect because we would have concerns about that. I don't know, Katie and I could talk offline about that a little bit more if you want, but that's kind of what we're concerned about, is making sure that it's funded.
About July 1.
Yeah, well, that would, what date would you suggest that would be cover that.
Yeah, I think July 1 would cover it because then if it wasn't going to happen, then there would be time that session to move it out.
Let's just put that in. We can't project what this year's budget will be or the next year's budget, so let's put that in. And then that may become that's friable. I mean, it may change going forward. New word. Okay, so, the issue that I brought up earlier, I think, can we address that? I think it relates to page 12. It also relates to page 30. I think the notice to the victim. So Katie, you're gonna have to help, and I think Karen and Stuart are gonna have to help with them, Karen especially. So page 12. The testimony is from Joanne Hortendick. Her comment was to have some parallel language, that the language included in the House Judiciary version of S-89 that was used by Ledge Council in making revisions to the portion to persons with intellectual disabilities. And I'm wondering whether this is what we just took out. I'm not sure.
I think I can clear this up really quickly if you give me
Please.
an opportunity. Yes. So the language, I think this is just simply a misunderstanding. The language that we added in the Dale section around victim notification already exists in the DMH world. It's already there in 18 VSA 4822. If you guys remember S3 back, or Act 57 back in 2021, that's our language that we added. We are simply adding it to the Dale population in this bill. So we already do this notification. So it already exists. I think it was just a misunderstanding.
Okay, that's helpful. Thank you. I didn't go any further than looking up 7618, or that would be. Okay. So we don't need this language to assure notification.
Not for DMH, no.
Okay.
And Karen, I guess the question I have for the committee is, if we're pulling over the language around notification to the victims, is there also a corresponding provision in the DMH statutes that provides for an opportunity for the victims to request a hearing and to stay an administrative discharge if it's being made by the commissioner?
It's similar, yeah. So it's
Okay.
the state's attorneys that have to provide that victim notification, and then it's a little more sensitive in the DMH world, right? Because at that point they're in family court, and those proceedings by statute are confidential. And so there was HIPAA concerns. And so what we did was we said the state's attorneys would provide the notice to the victims, getting around the HIPAA issue, and then the state's attorneys can ask for a hearing. And so that's how we dealt with it that way, because it is a little different. Ours are protected health information, right? Versus yours, which are in the criminal realm and thus not protected. So yes, it looks a little different, but it's the same concept. And it is working now. As I said, we started notifications back in 2021. And so we do these now.
Okay, you're bringing back memories. Thank you. Okay, we'll rely on your.
So to Stuart's question though, Stuart, do you still think we should slash that paragraph that you suggested?
Well, I am curious as to how the process works when it is the commissioner who's making the recommendation for discharge in DMH from DMH's custody as opposed to the court. Is there a court proceeding that allows the state's attorney or the victim to challenge the commissioner of mental health's decision to discharge? If there is,
Yeah, go ahead.
yeah, if there is, what I'm hearing is that that's done in family court, which is where these discharges would be as well for those with intellectual disability. It just struck me.
Oh, so here's what, go ahead, finish up, and then I want to make a comment. Go ahead, Karen.
I was going to say, kind of, but ultimately, right, it is the decision of the commissioner. What it gives them is an opportunity to be heard. But ultimately, it is the decision of the commissioner whether or not to discharge from custody. But this is giving them notification and an opportunity to be heard. It doesn't change the fact that we cannot keep someone in a facility unless there's a clinical need to do so. The idea behind it was that, one, we were giving victims notice so they know that someone is coming out. And two, if they just wanted to be heard, we heard and I think I've heard this a lot from Joanne and Kelly too, right? They want to be heard. They want to make sure people are hearing them. And so it gives them that opportunity. It doesn't ultimately change the outcome unless
Okay.
there's new clinical evidence presented.
Yeah, so there
So
is,
there is a hearing then.
yeah, well, it could
They
be,
want one, not necessarily, but they can ask for one.
yeah, they can ask for a request for a discharge hearing to be held within 15 days is what the suggestion is here. So Katie, your thoughts on this, and then we might have to have you evaluate this out of committee and bring us back what we might, our policy decision on this.
For what it's worth,
Sure, go ahead.
Senator, Dale would support a parallel structure with DMH in this realm. I think it's important then,
Yeah.
if we're going to give notice to victims and the state's attorney and the attorney general, that we also give them an opportunity to ask for a review. And if it's working in DMH, I think that in the interest of creating parallel structures, then that would be fine. And so kindly disregard my previous comments where I suggested that maybe it should come out. I'm glad to hear that it's working.
What the request in the witness testimony is that there's no logical, I'm reading from the testimony. There's no logical reason to include those discharge provisions in the section of the bill pertaining to those in Dale custody,
Mhm.
and not include them in the section of the statute pertaining to those in DMH custody. So the reverse.
Mhm.
So let's allow for Katie to, look, do you want this?
Sure.
I have a printout copy that.
I think what I'm figuring, Madam Chair, if I may,
Yes,
What Karen is saying is that it's already in statute.
yes, that's
for
what we're,
DMH. And
so
what,
we don't need to add
we
it.
don't need to add it, it's already there. And what Stuart is saying is, given that it's already there in DMH, he rescinds his request to delete that
But there's-
paragraph on the top of page 31, which is the
But
paragraph.
I wanna make sure that there's no language in there, I don't think there's language in this one about a stay by the courts.
this does create that. Once the hearing is requested, the pending administrative charge shall be stayed until reviewed by the court.
Says
Is
review.
there a stay in DMH's role, Karen? Similar type thing?
That's
Yeah, that's what this is.
Yeah.
Well, so that's the question, so let's leave it, well, unless you can resolve it right now. If there's a stay, we need to decide, do we wanna have a stay? Or is it the commissioner's decision, which is probably, I don't. So if there's a stay in one place, do we want them in both places, or do we want them in neither place? That's the question. Do you have a question?
Just a comment that I concur with Stuart about consistency and.
Yeah.
I like the idea that, we're listening to the voices of folks who've been involved here.
Right, that's what this is,
Yeah.
yeah. It's difficult sometimes for that testimony. I know, did you turn it up to 90?
I turned it up, it's really freezing in here.
It is,
And I'm not usually a cold person.
yeah.
There's no stay, but we have to give the 10-day notice so they can have the hearing within the 10 days. So we have to give 10 days. So we can't discharge before the 10 days are up, but
But there's no stay.
additional beyond 10 days, no.
So we could cross out that last line,
Right, so
which
there's,
is what Stuart originally was talking about.
For clarity, can you tell me what page we're on?
Top of
page 31.
That's what I thought, and what line?
Lines 1, 5, and 6.
Yeah, we.
Katie, what are you thinking?
Just wanting to. After request. Is that the same language, Karen? Which shall be heard within 10 days after the request?
Yes, there's also a 15-day. Oh, the hearing held within 15 days. What I'm looking at here. From 13 VSA section 5301. That's the victim. Oh, then the state's attorneys, there's no reference to that, so that might be new language. Sure. I don't know. But the stay piece, the state's attorney or the attorney general's office and the victim are entitled to.
Maybe we
They
should,
get the discharge. This one says. Once the hearing is requested, pending administrative discharge shall be stayed until reviewed by the court. I don't know why that's there. That's a question for legal counsel to help us understand what the decision was.
You just struck lines 5 and 6 this
Yes.
way. So now Karen is checking that the language in our draft, lines 4 and 5, which shall be heard within 10 days after request, matches the mental health statute.
It. Sorry, I have too many screens. Give me one moment.
maybe we should just ask Stuart, Katie and Karen
To get together
to get
offline?
together offline and
I
check
wanna
it.
do that, but I wanna give us some more time on the bill. Can you do that? Can we go through the bill one more time?
Sure.
Please. And our work on S-151 is going to be extremely brief today. And then we'll be setting testimony up the next time we look at it.
I do have some comments on the panel, if it's possible to give those whenever you're ready.
Please give us your comments on the panel before we start going through the bill again.
Okay. So I think the policy question is, what are you hoping to achieve from the panel? Because this process is already occurring. So I just wanted to kind of provide some context. So admission as we envision it and is already happening in River Valley is a two-step process. It is solely the decision of the commissioner whether or not to ask the court to allow the person to be placed in the forensic facility. And that's because it is the commissioner alone that has the burden to prove to the court that they meet this standard, that there's no less restrictive place where they can be served. And I'll explain more in a second. That's decision isn't made in a vacuum, but it's informed by clinical and legal by a lot of different people. But that's not the end of the process. The commissioner makes that decision, but ultimately it's up to the judge to decide whether or not to allow the commissioner to place the person in a secure facility. Or the court can make the decision that the person can be served in a less restrictive setting. And this is where legal aid comes in. They can get their own experts and they can put on their own testimony, arguing that the state has not met the burden and that their client should be served in a less restrictive setting. And then just like any other contested court hearing, the judge weighs both the positions and makes a decision based on the evidence. I think it's important to remember that this is a new concept to the forensic facility and a new level of care, but it already exists for those at River Valley. So we know how the process works. We really just adapted the River Valley statutes to the new facility and then added a little extra, but the basis is the same. So we at DMH, we meet weekly to discuss all new forensic cases. The commissioner, myself, our assistant attorney generals, our medical director, and our care management team. And we review everyone whose evaluations have come in and they've been found incompetent. We do the same if they were found insane, but that's pretty rare. In addition, the care management team and our assistant attorney generals who do our litigation meet with all facilities and their medical personnel once a week and discuss every patient or resident in our care, including how they're doing, whether or not they're getting ready for discharge, and whether or not we need to think about renewing custody. DMH also meets regularly, I think weekly, but it could be bi-weekly, with DOC and Dale to discuss individuals we share, and we ask the same questions. Where are they? Where should they be? Are they close to discharge? Do we need to seek to put them in custody or retain them in custody? And if so, whose custody? The idea behind the panel was just to make sure that work was continuing. The right clinical folks in between the departments were talking. This will continue regardless of whether or not there's a panel, and in fact is occurring more regularly and is less administratively burdensome the way it works now. The report of the panel isn't likely to be any different than the filings in court, because it's the filings that really matter. Because again, the court is making the ultimate decision and we have the burden to prove to the court. And again, remember, the person has legal representation in the courtroom and can argue that we haven't met our burden. That's where they can get their own experts, present their own testimony. So it's a policy question. I wonder, though, the idea behind it, again, was to make sure AHS was bringing all the right people to the table. There could be a requirement that AHS work together internally to make sure we're exploring all the options. Because adding people to the panel isn't going to change the outcome. It's really legal aid in court that's making an impact on the outcome if legal aid disagrees. Now, there are certainly cases where legal aid agrees, right, where we stipulate to an order. But if they don't agree, then they have that opportunity, and the forum is in the courtroom because it is the judge that's making that decision. Does that make sense?
Yeah,
That's helpful.
does, go ahead, and then I'm gonna suggest that as we read through about the panels on page 1, because on page 1, as we read through that, then we think about if there's any language change we want to make related to what you just said. Senator Hurry, go ahead.
Yeah, I mean, that's kind of what I heard similar yesterday. I think Stuart said a similar thing. So you're both consistent, which is lovely. And that is, so I feel like the panel it's because it's an internal panel anyway, it doesn't seem necessary. It seems like an added kind of administrative thing that might delay these decisions. If we're gonna have some kind of panel to make sure that everybody is talking, then it seems to me that it should have some external people on it to keep the internal people, you know, honest or whatever, not that you're not dishonest, but you know what I mean, just as an accountability check. And if we're not gonna have external people on it, then I just think we shouldn't have the panel, because it's just an extra.
So so Karen and Stuart, don't go away. That is the issue. And whether legal aid or disability, the Disability Council or anyone else belongs in that discussion is an important piece for us here. So let's go through the bill, and because the panel is right here on the first page, we'll get to that discussion pretty quick. Are you planning about comment again?
Committee at 11.
Pumpkin. Darn. Okay. All right, well. When we're coming back to this. We've got to go to a joint thing tomorrow, but I don't think we're. Tomorrow's. Where's my agenda?
On Friday is when I have it on my.
It's
phone.
Friday, isn't it? When it's right here in front of you. Friday, so. Nuts. In the meantime, let's put our thinking caps on about two things, the panel and then the bill as whole. And if there are any changes that we think we might want to make. Yes.
I agree with Senator Hardy that it seems like it's almost like a little bit performative in the bill. It's sort of like an outward facing, this looks good, but does it actually do it?
Well, that's a discussion that we can have, when we come back, and then think about whether or not other external or internal, because Disabilities Council is internal to state government. So also is legal aid in many ways, so if we want to have additional folks on there.
We're just
Well,
not have it.
Or not to describe the panel itself, but that there is an internal process that includes reaching out. Because you don't want to leave it I think there's some reassurance given to victims, families and others that there's a process going on before decisions are made. And then, of course, the work that's presented to the court is going to be comprehensive. So we'll do that. So is Jen on her way? Okay, so we'll do that. That's where we are with this. Don't go right for my agenda. I know this. All right, we can go off live until Jen gets here.